And you represent Mr. Mr. Roof, is that correct?
That is correct, Your Honor.
All right, and who else represents Mr. Roof for the record?
Your Honor, for the record, Dylann Roof.
Teresa Norris, Your Honor.
Okay. All right, do you want me to address the question to you, Mr. Pennington, or all three of you? How do you wish me to proceed?
Probably ask the questions of me, and if I need to confer with counsel, I'll ask the court's indulgence.
Okay. All right, have you explained to your client the charges contained in the various indictments?
Yes, sir, I have.
Have you explained to his possible punishment?
Yes, sir.
Have you explained to his constitutional rights?
I have thoroughly, Your Honor.
In your opinion, does he understand the charges, the punishment, and the constitutional rights?
I believe that he does.
In your opinion, is he able to assist you with the defense? Keep in mind the ability to assist and willing to cooperate is not the same.
I believe that to the extent that there were any questions about competency, that we're not raising any concerns or questions about his ability to proceed.
Now I understand you want to protect the issue that was raised in federal court previously, is that correct?
Yes, sir.
And that was raised pursuant to a letter that your client wrote to the attorneys, and they had two competency hearings in federal court, is that correct?
That's right. There were extensive hearings, there were pleadings, there were reports by experts on both sides of the question, and there were orders issued by Judge Gergel, which the court has and has referred to, and which I think bring us here today.
In your opinion, does the defendant have the mental capacity to assist you in preparing for this plea and or a trial if it was necessary?
Your Honor, we see no issue. We're not raising any issue at all about that.
Do you think he's competent to enter into the plea today?
We're not raising any. We have no questions that have not already been addressed, litigated thoroughly, and ruled on in federal court.
Okay. All right, since your client was found to be competent by Judge Gergel on November the 25th and on January the 18th, has anything changed, including his demeanor, his appearance, his knowledge, his understanding, and abilities that would impact his competency since January, the last evaluation on January the 18th up till today?
No, sir.
Because I'm of the opinion, according to the cases in South Carolina, that's the area that I'm concerned with.
I understand, Your Honor, and what our position is that there's really no issue, no new issue that's presented itself from the dates in January that you cited and today's date.
All right, Mr. Roof, if you'll raise your right hand, please. The best you can. Thank you, sir. You swear to tell the truth and nothing but the truth, so help you God?
I do.
All right, Mr. Roof, during this process, I'm going to ask you some questions, okay? If you want to discuss any of the questions with your attorney, please let me know. I'll give you an opportunity to do that. Do you understand?
I do.
If you don't understand the question, please tell me. I'll try to rephrase the question, or you may discuss it with your attorney if you so desire. Do you understand?
Yes.
All right. Most of the questions are relatively simple, and I think you won't have any difficulty in understanding. First of all, what is your full name?
Dylann Roof.
All right, what's your social security number?
I'm not sure.
All right, what's your date of birth?
April 3rd, 1994.
And how old are you now?
23.
Okay. How far did you go to school? Did you complete high school?
No, sir.
Did you get a GED?
Yes.
When did you get your GED? Approximately.
Late 2014, maybe?
Okay. All right, how far did you complete in your formal school?
9th grade?
The 9th grade, you completed the 9th grade?
As far as I know.
Okay. After you dropped out of school in the 9th grade, what did you do? Did you stay at home? Did you work? Or what did you do?
I had one job for on and off.
All right, what type of work did you do in that job?
Landscaping.
I'm sorry?
Landscaping.
Okay. What did you specifically do? Manual labor or what?
Cut grass.
Cut the grass. Okay. How long did you do that job?
First time, probably about 3 months.
2 months? Okay. Who did you work for? Do you remember?
Yes, Clark's Pest Control.
Okay. Have you held down any other type of jobs?
No, sir.
Have you lived primarily at home, or have you ever resided on your own?
No, I've always lived at home.
and with your mother?
Yes.
Have you ever been married?
No.
Do you have any children?
No.
I understand that you've been in the criminal court system, primarily the federal charges that you tried back in January across the street here in Charleston. Other than that federal court case, have you ever been in criminal court before?
I was in a courtroom once, but I wasn't charged.
Okay. You was just sitting in the courtroom? Is that right?
Right, it was for one of my other charges for like trespassing.
Okay, all right. All right, Mr. Roof, within the last 24 hours, have you taken any medication, drugs, or alcohol?
No.
All right, Judge Gergel found you competent in November, again in January. Are you aware of any changes since then, or any physical, emotional, or nervous problem that might keep you from understanding what you're doing today or what is taking place today?
No.
All right, the court is aware of Mr. Roof's medical history pertaining to substance abuse and mental illness and have thoroughly reviewed those documents which be entered into the record under seal. And I believe that's marked this court's exhibit number 7. Okay, would you hand it to me, please? Just hand me the book. 1 and 2. All right, the court's going to mark the competency materials in Volume 1 that was delivered to the court by court order from Judge Gergel, which the court has reviewed and read and studied in great detail. And then Volume 1, which is marked as Court's Exhibit number 7, is a Dylann Roof letter to prosecution, a cover emailed to the letter to prosecution, transcript of November 7, 2016 hearing, Dr. Ballinger's November 15, 2016 competency report, Dr. Wagner's November 14, 2016 psychiatric report, Dr. Ballinger's CV, Dr. Wagner's CV, transcript of November 23 and 22, 2016 competency hearing, transcript of November, also day 2 of the competency hearing, findings of facts and conclusion of the law, December 25th on the defendant's competency, and Judge Gergel found Mr. Roof to be competent. And in Volume 2, which the court has reviewed, there was Dr. Ballinger's January 1st, 2017 competency report, Dr. Lofton's psychiatric report, Dr. Mossberg's psychiatric report, Dr. Maddox's psychiatric report, Mr. Robinson's report, declaration of David Bruck, Emily Pavlone, Emily Stevens, transcript of January 2nd, 2017 competency hearing, memorandum of opinion January 6, 18, 2017 on defendant's competency, of which Judge Gergel found Mr. Roof to be competent. Is anything else you would like to add as to the competency issue today since January to that issue?
Nothing on that.
And primarily, I'm referring to the email that you sent to the court, I believe last week on Tuesday, April the 4th, which I marked as court's exhibit number 6. And I'm asking to please address that.
Your Honor, just that we've conferred, again, we're not raising any issue about Mr. Roof's competency to enter this guilty plea. The questions that we have had raised in the federal court have been litigated, raised, and ruled upon, and therefore there's no new issues to present at this time.
And since the last evaluation, you agree that there's been no change that would interfere with his ability to assist you in preparation for this guilty plea?
There's been no significant change that I've been able to discern, Your Honor.
And you understand the standard for the guilty plea is the same as the standard for trial?
Yes, sir.
Mr. McGuire?
Yes, sir.
Do you also agree with that?
I do.
Ms. Norris, do you also agree with that?
Yes, sir.
Okay.
Your Honor, may we inquire, I think I heard you say, but I just want to confirm, Mr. Roof asked me, obviously these are matters that are under seal in federal court. And
They're going to be under seal here. I thought I already said they're under seal.
I just wanted to verify. Thank you, Your Honor.
I'm going to place them under seal. They will not be open except by a circuit court judge or appellate court judge on a direct appeal or direct attack of this or any collateral attack as to this guilty plea, such as a PCR.
Very good. Thank you, Your
Okay.
Honor.
Now, for the public and the news media benefit, I understand Judge Gergel is going to release that material at some appropriate time after proper redaction of certain medical records. When that's appropriate, you'll have to ask Judge Gergel. Now, I've questioned both the defense attorneys and defendant on the issue of competency. I'm not going to order further evaluation or a competency hearing for the following reasons. Mr. Roof's appearance of capacity today while answering the question, Mr. Pennington stated to court repeatedly would not raise competency as an issue on behalf of his client. And we discussed the email earlier. Judge Gergel found Mr. Roof competent on January 24, 2017. I've already gone over the documents that have been marked as court's exhibit. I won't go over them again. I've thoroughly reviewed those documents to consider them. These documents will be marked as court's exhibit, as I said earlier, under seal. And as I said earlier, Judge Gergel found him competent. And I would like to state and refer to the following cases whereby the courts of the opinion that since there was a mental capacity evaluation done, one approximately 2.5 months ago and another one about 5 or 6 months ago, there's no need to have a composite evaluation at this time, just merely the issue of whether anything's changed since its last evaluation. The test is not whether the defendant is actually cooperating with his attorney, but rather if he has the mental capacity to do so. That's State versus Reed, State versus Bell. And where the defendant has been found competent, the mere fact that one time lapsed between the determination and the trial does not automatically require a reevaluation pursuant to State versus Adams, State versus Drayton. And State versus Drayton says, failure of trial judge to order further examination and hearing to determine the defendant's capacity to stand trial did not violate the statute authorizing the trial judge to order such examinations or deprive the defendant of due process of the law where previous presiding judge had found about 2.5 months before the defendant was fit to stand trial. There was no additional facts to warrant further examination or hearing, and while contending that the defendant was not competent to stand trial, his counsel refused to demand further competency hearing and stated referring to prior determination. We believe that that has already been accomplished. Pursuant to State versus Bradley, when reviewing the statutory injunction in sections 44, 23, 410, this termination requires discretion is within my discretion. I also rely on State versus Burgess with regard to discretion, State versus Motts on presumption of continued competency. All the cases I have referred to will be entered as court's exhibit. Based upon these considerations together, I find that Mr. Roof is still competent in this plea. He does so knowingly, intelligent, voluntary, with full understanding of the offenses against him. Mr. Pennington, how does your client wish to plead? I believe you previously said he wished to plead guilty. Is that correct?
Yes, sir, on all counts.
All right, from your investigation, facts, and circumstances of the case, do you feel that the state can produce sufficient evidence to convince the jury of his guilt?
Yes, sir, I
And
do.
you feel it's in his best interest to enter the guilty plea?
Yes, sir, I do.
All right, Mr. Roof, you're pleading guilty to 9 counts of murder and 3 counts of attempted murder. Is that correct?
Yes.
And a weapons charge. Your Honor.
Pardon?
And a weapons charge.
I believe we have to deal with the weapons charge later, but Mr. Pennington has an objection to that. Is that correct?
Only, it's not an objection so much as a comment about how the statute reads. And
I understand the statute reads that basically you don't sentence them when you got it covered.
That's my reading of it, Your Honor.
Okay, all right. Mr. Roof, do you understand that the possible maximum sentence for the murder under the negotiated plea would be life? without parole, do you understand?
Yes.
And you have 9 murder charges, that would be 9 life without parole, do you understand?
Yes.
Have any question of that?
No.
On the 3 attempted murders, you could receive up to 30 years on each one, do you understand?
Yes.
Have any question about that?
No.
Do you understand the possible maximum sentence you could receive on all of them? Do you understand?
Yes.
Do you understand that you will not be eligible for parole on the life sentences?
Yes.
It means what it says, life without parole, do you understand?
Yes.
Do you understand fully the nature of the charges against you and the range of possible sentences?
Yes.
You understand when you enter a guilty plea, you give up certain constitutional rights, do you understand?
Yes.
You give up a right to a jury trial, do you understand?
Yes.
At a jury trial, the state would be required to prove you guilty beyond a reasonable doubt, do you understand?
Yes.
You could offer witnesses on your behalf as to a defense, do you understand?
Yes.
Your attorney could cross-examine witnesses, present evidence on your behalf, and the jury would unanimously have to find you guilty, do you understand?
Yes.
You could offer testimony on your behalf, or the attorney could offer other witnesses on your behalf, or you may testify on your own behalf if you so chose, do you understand?
Yes.
Knowing that about a jury trial, do you want a jury trial?
No.
Do you understand that you have the right to remain silent on the Fifth Amendment of the Constitution?
Yes.
No one can make you testify against yourself, do you understand?
Yes.
When you enter a guilty plea, you will be acknowledging your guilt, do you understand?
Yes.
When you acknowledge your guilt, you will be testifying against yourself, do you understand?
Yes.
Are you willing to give up your Fifth Amendment rights today to enter your guilty plea?
Yes.
You understand by entering your guilty plea, you're giving up all your constitutional rights. You understand?
Yes.
Do you understand you have a right to appeal the guilty plea 10 days from today? Do you understand? You have that legal right.
Yes.
Now, you have entered into an agreement whereby you are waiving your right to appeals. Do you understand?
Yes.
You got a copy of that. I believe you entered into that April the 10th today, is that correct? Is that correct, Mr. Roof?
Yes, that's correct.
At least it's dated today, is that correct?
Yes.
You signed it? Is this your signature on the document I'm looking at?
Yes, it is.
Do you understand that no one can force you to waive your right to appeal?
Yes.
If anybody forced you, threatened, intimidated, make you sign this waiver?
No, they haven't.
You understand when you sign this waiver, you will not be able to make a direct appeal to this case.
Yes.
When I say a direct appeal, I mean appeal it to the Court of Appeals of the South Carolina Supreme Court, you understand?
Yes.
And this appeal does not affect any type of collateral attack on this guilty plea, such as a PCR or some other legal collateral attack, do you understand?
Yes.
Which is, PCR is on the civil side of the court, not on the criminal side. It's not, you understand?
Yes.
Have any questions about this plea agreement, this waiver for the appeal?
No.
Did you fully understand the conversation you had with your attorney about the waiver of the appeal?
Yes, I did.
Mr. Pennington, have you fully explained the appeal waiver to your client?
Yes, sir, I have.
Do you think it's in his best interest to enter that agreement?
I certainly do.
And do you have any difficulty communicating with him about the agreement?
On this subject, not at all.
Do you feel like he fully understood that agreement?
I believe that he does.
Mr. McGuire, have you discussed it with your client?
Yes, sir.
That you are of the opinion that he fully understands the agreement?
Yes, sir.
Ms. Norris?
Yes, sir, I agree.
Thank you so very much. All right, I'm going to mark the plea agreement as court's exhibit. Another constitutional right you have, Mr. Roof, is a presumption of innocence. You're presumed innocent until you walk into the courtroom and the state has proven you guilty beyond a reasonable doubt and all 12 jurors have found you guilty. Do you understand?
Yes.
In waiving your jury trial, you're giving up that right of a presumption of innocence. Do you understand?
Yes.
Have any questions about that concept?
No.
Now, I think we discussed this before, but you do understand that the sentence of life without parole means what it says. You will never be eligible for parole. Do you understand?
Yes, I understand.
Has anybody coerced you
No.
enter your guilty plea?
No, they haven't.
Has anybody coerced you to enter into the plea negotiation agreement and or the waiver of your appeal?
No.
Has anybody intimidated you?
No.
Have you had enough time to make your decision and your guilty plea?
Yes.
Have you had enough time to consider whether or not you want to sign the appeal waiver?
Yes.
Have any promises been made to you other than the plea negotiation of life without parole and removal of the death penalty?
No.
All right. Now, there's also in the agreement about federal custody and the, what's the court exhibit, what number is it? It's not in there? Custody. All right, in the memorandum of agreement on the transfer of primary jurisdiction, in that agreement, it says that you will serve your time in federal custody, you understand?
Yes.
And you signed it, is that correct?
Yes, I did.
I believe your attorney, Mr. Pennington, signed it, who represents you here in state court, and your attorney, David Brooks, signed it, who represents you in the federal court, is that correct?
Yes.
And it's also been signed by Beth Great, the United States Attorney District of South Carolina, by Mr. Wheeler, Acting Assistant Attorney General, Civil Rights Division, and by the Solicitor Scarlett Wilson. Do you understand?
Yes.
Now, I understand it in everybody's opinion that you will serve your time in federal prison. What I want you to understand is no one in this courtroom can guarantee that or promise that. Do you understand?
Yes, sir.
This court doesn't have that authority to order the Federal Bureau of Prisons to accept you, nor does your attorney, nor does the solicitor. Do you understand?
Yes, I understand.
That's strictly up to the Federal Bureau of Prisons to accept you. You understand?
Yes.
Now, according to everybody's opinion, that's going to happen. Do you understand?
Yes.
But I have no way of controlling that's what I want you to understand.
Yes, I understand.
Does that interfere with your ability to enter this guilty plea today?
No, it doesn't.
Thank you very much. Are you entering this guilty plea of your own free will and accord?
Yes.
Have you understood all my questions?
Yes.
Have you answered them truthfully and correctly?
Yes.
Do you have any question when asked the court or your attorney about anything that I have asked you up until this time?
No.
All right. All right, the following questions, Mr. Roof, apply only to your state attorneys, okay? Mr. Pennington, Mr. McGuire, Mr. Norris, not to any attorneys represented you in the federal case, you understand?
Yes.
Are you satisfied with your attorneys that have advised you and represented you in this case?
Yes.
Have you talked with your attorneys often and for as long as you feel necessary for them to properly represent you?
Yes, I have.
Do you need more time to talk to your attorneys?
No.
Have you understood your talks with your attorneys?
Yes.
Have your lawyers done everything where you feel that they should have done?
Yes.
Is there anything that they have done that you feel that they should not have done?
No.
Are you completely satisfied with your lawyer services?
Yes.
Do you have any complaint you want to make about your lawyers in any manner whatsoever?
No.
All right, do you understand on the pistol charge you can receive up to 5 years? Do you understand? However, under the interpretation of statute in the South Carolina case, the court will not sentence you because the life sentence will cover that time period. Do you understand?
Yes, I understand.
Okay. Thank you very much. All right, Mr. Roof, are you willing to give up the constitutional rights that I previously explained to you?
Yes, I am.
How do you wish to plead?
Guilty.
And are you guilty of the 9 murder charges, the 3 attempted murder charge, and the pistol charge?
Yes, I am.
All right, what I'm going to do at this time, Mr. Roof, I want you to listen. I'm going to ask the solicitor to give me the facts in the cases, okay? And after she gives me the facts, I'm going to ask you if you agree with those facts. If you disagree, I want to know specifically what you disagree with. Can you do that?
Yes.
Solicitor.
Thank you, Your Honor. Your Honor, as you might imagine, there has been a lengthy investigation and there are mounds of evidence against this defendant. I'm going to give you a brief summary of the facts that we would have presented had we gone to trial. And most of them I understand you're familiar with, but we need to make our record for the court. As you know, this occurred on Wednesday, June 17th of 2015. The victims that were listed in the indictment, DePayne Doctor, Clemente Pinckney, Daniel Simmons, Cynthia Hurd, Susie Jackson, Ethel Lance, Sharonda Singleton, Myra Thompson, Tawanza Sanders, and also Felicia Sanders, Tawanza's mom, and her grandchild, and Miss Polly Shepard, all were of Emmanuel Church, and they had gathered for a meeting and Bible study at Emmanuel Church here in Charleston County. These 12 students and teachers of the Bible weren't alarmed when the defendant arrived and entered and wanted to join their Bible study, and in fact, as I'm sure you've heard, they welcomed him. He sat down with them, he joined them, and they listened and they studied the gospel alongside him. Meanwhile, Reverend Senator Pinckney's wife and daughter were in an adjoining study, or pastor's office, just outside of where the Bible study was taking place. After close to 45 minutes of study and of fellowship, and around the time of the closing prayer, the defendant took his .45 caliber pistol and opened fire. Reverend Pinckney was the first to be murdered. Reverend Simmons was next, and the others after that. As the women sought cover and huddled together, the defendant walked the floor and systematically fired at each of them, striking the 9 victims multiple times. As he walked around in the fellowship hall, shooting these innocent people, Tawanza Sanders tried to reason with him, telling him that they meant him no harm and that they didn't mean to cause him any difficulty. He made a number of racist statements in the fellowship hall and continued to shoot and kill Talonza Sanders along with the others. Miraculously, somehow, Felicia Sanders and her grandchild and Polly Shepard were not struck by gunfire. Immediately, Your Honor, a manhunt was led by Chief Mullen of the Charleston Police Department and Chief Keel with SLED. Their departments worked together, and the FBI became involved immediately as well. And this was truly a joint investigation by those agencies, SLED, CPD, the FBI, and then on into North Carolina with agencies there. The defendant was apprehended the next day in North Carolina. He gave a knowing and voluntary confession to FBI agents who did a remarkable job of interviewing him. In addition, CPD, with the help of Miss Althea Latham, who worked at the Mother Emanuel Church, they recovered a video that showed the defendant entering and leaving the church that night. The investigation continued, and it revealed that the defendant had planned this attack for months, and that his planning including research of Mother Emanuel AME, scouting trips to Charleston, and that his plan was to kill specifically innocent African Americans, and his hope was to start a race war. As I mentioned, Your Honor, there are mountains of evidence against the defendant, written confessions, a verbal confession, and these would have been the facts that we presented had we gone to trial.
Okay, thank you, Solicitor. Mr. Roof, do you agree with those facts?
May I have the court's indulgence?
Yes, sir.
We're ready now, Your Honor.
Mr. Roof, do you agree with those facts?
Yes.
All right. I find that Mr. Roof is free to volunteer, knowingly and intelligently made the decision to plead guilty to his licensed attorney. All elements of the charge has been met. There's two areas that I may have slipped my mind and not gone over. I want to go over very briefly. Mr. Pennant, has Mr. Roof had access to all the discovery materials and evidence against him in this case?
Yes, he has, Your Honor.
Mr. Roof, do you agree with that?
Yes.
And the plea negotiations, there's been plea negotiations, I think I referred to them when we first started. Has there been any other negotiations, Solicitor? Other than
None.
withdrawing the death penalty and entering the plea to gave to life?
No, Your Honor, and in fact, there is a paragraph in the plea agreement that explicitly states that is the entire agreement.
Have we marked the plea agreement?
I have filed it with the clerk, and I've sent you a copy, so it should be public.
It's marked. Okay, I think I marked this court's decision. All right, look, Mr. Pennant, any other plea negotiations that you haven't just told the court or the court's aware of?
No, sir, the court's covered everything that we've discussed.
Okay, thank you so very much. All right, Solicitor,
Yes, sir.
I'd be glad to hear you from any victims that would like to speak. I'd be glad to hear anything that they would like to tell me.
Yes, sir.
May I have the court's indulgence? Just a
Yes,
moment?
sir.
May I have your question?
Yeah.
That's fine. I'm just playing this.
All right, thank you so very much. Mr. Pennington, I thought I had said that all elements of all the charges have been met. And if I didn't make that clear, I hope it's clear now.
Yes, sir, it is, and
I did not enumerate the elements of murder and the pistol and the attempted murder, but all those elements have been met based upon what the solicitor had told the court and what Mr. Roof confirmed occurred.
And we did go over those elements before the hearing today, so that Mr. Roof is familiar with the formal elements of each of those offenses under South Carolina law.
Okay, all right. So I'll be glad to hear from any of the victims or their families, anyone you would like for me to hear.
Okay, thank you, Your Honor. As you know, there has been a lengthy federal trial across the street, and the victims' families and the surviving victims were present throughout. They have been present and supportive of our prosecution as well. They understand, Your Honor, that this is a negotiated plea, that this sentence is carved in stone.